In Washington, D.C., a federal judge handed a victory to the House Democrats on Friday when she ruled that they are legally engaged in an impeachment inquiry. A decision that undercut 45's arguments that the investigation is a sham, which it's not. The declaration came in a 75-page opinion by Chief Judge Beryl A. Howell of the Federal District Court in Washington. She ruled that the House Judiciary Committee is entitled to view secret grand jury evidence gathered by the special counsel Robert Mueller. Typically, Congress has no right to view such evidence, but in 74 the courts permitted lawmakers to see such materials as they weighed whether to impeach the then President Richard M. Nixon back in 74. The House is now immersed in the same process focused on 45. Judge Howell ruled, and that easily outweighs any need to keep the information secret from lawmakers. In a rebuke to the 45 administration, while the House had actually strengthened the lawmakers' case, she cited 45's vow to fight all congressional subpoenas in an extraordinary directive by his White House counsel, Pat Cipollone. The executive branch officials should not provide testimony or documents to impeach investigators. The White House's stated policy of non-cooperation with the impeachment inquiry weighs heavily in favor of disclosure. Judge Hall wrote, Congress's need to access grand jury material is relevant to potential impeachable conduct by a squatter is heightened when the executive branch willfully obstructs channels for accessing other relevant evidence. The administration is likely to appeal the ruling. The Justice Department was revealed. It came on a day when House investigators unleashed another round of subpoenas. They demanded that the acting head of the White House Budget Office and 2 other administration officials testify next month in their inquiry into 45's pressure campaign on Ukraine to open investigations that could benefit him politically. Democrats praised Judge Howell's decision. Representative Gerald Nadler of New York, the chairman of the Judiciary Committee, applauded the thoughtful ruling and its recognition that our impeachment inquiry fully comports with the Constitution. This grand jury information that the administration has tried to block the House from seeing will be critical to Nadler said in the statement. In arguing that the impeachment inquiry is a sham, Republicans have noted that the full House was not voted for a resolution to authorize one, as it did in 74 and 98 at the start of the impeachment proceedings targeting Nixon and Bill Clinton. Democrats have countered that no resolution is required under the Constitution or House rules, and pointed out that impeachment efforts to remove started up with such a vote. Judge Howell agreed with the Democrats, calling the Republican arguments cherry-picked and incomplete and lacking support from the Constitution, House rules, or court precedents. Even in case of a squadral impeachment, a House resolution has never in fact been required to begin an impeachment inquiry, wrote Judge Howell, she was an appointee of President Barack Obama. Though the impeachment inquiry has broadened to focus on investigating the Ukraine scandal that erupted last month, the dispute before Judge Howell arose from an earlier stage, the aftermath of the Mueller investigation. His report about the Russia investigation and 45's efforts as squatter to obstruct it, Attorney General William Barr turned over most of the report to Congress, but he censored portions that contained material that is secret under grand jury rules. Lawmakers demanded to see that text, as well as underlined documents and transcripts of testimony by witnesses who appeared before a grand jury in July. They filed a petition asking Judge Howell to order the Justice Department to provide that information under the Watergate precedent. In its legal filings, the House Judiciary Committee asserted that it was already conducting an inquiry into whether 45 should be impeached. At the time, Speaker Nancy Pelosi was seen as reluctant to put forward a resolution formally authorizing such an inquiry to avoid jeopardizing newly elected Democrats who won seats in moderate districts in 2018 midterm elections. But in September, as a revelation about 45's Ukraine dealings fueled support for an impeachment inquiry, Nancy Pelosi announced that one was underway, but stopped short of bringing a resolution to the floor. Republicans in Congress have seized upon the lack of a formal vote as their foundation for their opposition to the inquiry, focusing on process instead of the substance of allegations against 45. As of Friday, all but 3 Senate Republicans, Senator Lisa Murkowski of Alaska, Mitt Romney of Utah and Susan Collins of Maine had signed onto a resolution that accuses Democrats of conducting an unfair inquiry and calls on the House to vote for a formal impeachment investigation. Also on Friday, the Republican National Committee's governing body made the unusual gesture of declaring in a symbolic resolution that now more than ever wholeheartedly supports 45 in the midst of a partisan impeachment investigation. Both the 45 legal team and Republicans have adopted the lack of a formal impeachment vote as a basis for their arguments that the inquiry is illegitimate, stressing it both publicly and in letters warning executive branch officials not to cooperate when Congress asked them to testify and provide documents, including Cipollini's documents. Some administrative officials have defied that warning and testified anyway, while others have invoked the White House's directions to refuse to cooperate with impeachment investigators. One of the officials subpoenaed on Friday for testimony, Russell T. Volt, the acting director of the House of Management and Budget, had cited 45 Cipollini's letter when he announced this week that he had another top Democrat appointee. Then another top 45 appointee there, Michael Duffy, would not appear before Congress. Cipollini denounced the inquiry as constitutionally illegitimate. Duffy was one of the other officials who received a subpoena on Friday to submit to the depositions about whether 45's decision for Ukraine was part of a quid pro quo effort, which it was. The third was T. Ulrich Ruckel, if I'm saying that gay-ass name right, a counselor at the Senate Department. The new subpoenas, issued jointly by the House Intelligence, Foreign Affairs, and Oversight and Reform Committees, which are leading the investigation, suggested that Democrats intend to continue the private phase of their investigations for several more weeks before convening the public hearings. The subpoenas will also further challenge the administration's reluctance to cooperate with the inquiry. Mr. Breckbuell is a close ally of Secretary of State Mike Pompeo, another dumbass, and it is unclear whether he will follow the White House directive or defy it to join the other State Department officials who testified before impeachment investigators. We will not be participating in a sham process designed to relitigate the last election. It's not a sham. They already determined that. Mr. Vaught, one of the other officials who received the subpoena on Friday, said on Faux News this month. The budget office under Mr. Vaught's leadership has also refused to provide communications and other records for the three panels that could potentially reveal more about the handling of the aid package for Ukraine. The committees were also scheduled to hear in a closed session on Saturday from Philip Reeker, the acting assistant secretary of European and Eurasian Affairs at the State Department. Nicholas Fandos and Edward Long contributed to the reporting on this.